Joining our webinar this morning. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Alex Barthet, a Florida construction lien law expert. Today's webinar topic is, oh shit, I blew my lien deadline. Now what? So without further ado, I'd like to introduce the fabulous and wonderful Alex Barthet.
Thanks, Jesse. Again, my name is Alex Barthet. I am a board-certified construction attorney here in Florida, and today we're going to talk about what you can do if you miss a lien deadline. So let's get right into it. If you have any questions, go ahead and submit them in the GoToWebinar chat box. We will answer all the questions at the end. Please make sure not to include the names of any people or companies in your questions. All right, so what are we going to talk about? We're going to talk about the basic notice and lien rules, right? You don't know if you broke a rule unless you know what the rules are. Then we'll talk about the fact that maybe you actually only thought you failed to meet a deadline and maybe you actually didn't. And I'll explain some of those hidden traps and tricks. Is there a bond to go after? Sometimes you think that you missed a claim on a bond and maybe there's another one that you can pursue your claim against. We'll talk about other legal claims you can make, like suing for breach of contract, suing for unjust enrichment, which are two other alternative legal theories that may give you rights to get paid. And of course, we'll answer any questions at the very end. All right, so let's go through the basic rules, because you need to know the rules in order to understand whether or not you've met the deadlines or not. So rule number one, you need to serve your notice to owner no later than 45 days from your first work or delivery of materials to the job site. Again, remember, 45 days is measured in calendar days, not work days. And the 45th day, if it lands on a weekend or legal holiday, can potentially move to the next available business day. And the 45th day is the day it has to be received by the owner and the contractor. So if you put it in the mail on the 43rd day, you're probably going to miss the deadline if you send it via certified mail. The next rule is that you have to serve your notice of non-payment on any bond and or record your claim of lien no later than 90 days from your last work or delivery of materials to the job site. Again, 90 days is counted as every calendar day. If the last day falls on a weekend or legal holiday, you can move the 90th day to the next business day. And last work does not include punch list or warranty work. It has to be approved change order work or base contract work. The next deadline, you have to file a lawsuit to foreclose on your lien no later than 1 year from the recording date of the claim of lien. So if I record the lien today, a year from now, unless that date has been shortened, a year from now, I have to hire a lawyer and file a lawsuit in court to enforce that lien. If I don't do it within that 1 year, my lien is gone. I cannot re-record the lien. Now for bonds, bond claims, it's a little different. It's 1 year from your last work. So not 1 year from when you send the notice of non-payment to the bonding company. It's 1 year from your last work or delivery of materials to the job site. So remember, there's a distinction between the deadline to sue on a lien and the deadline to sue on a bond claim. Now, these are the basic rules. There's lots of exceptions. We'll touch on a few, but just know that there may be other exceptions that apply to your situation. So what are the most common exceptions? So number one, you may think you needed to send a notice to owner, but maybe you didn't. So if you have a direct contract with the owner of the property, you don't need to serve a notice to owner. So what does that mean? That means if you're the plumber and you're hired by the owner of the property, you don't need to send a notice to owner. So most people think plumbers are subcontractors, but again, if your contract is direct with the owner, you don't need to serve a notice to owner. I recommend that you do, but it is not legally required when you have a direct contract with the owner. No notice to owner is needed when you are a subcontractor and the GC and the owner share a common identity. Let me explain what this means. There are some owner builders out there, some small, some large, so that when you contract with, so let's say, again, let's take the example, you're the plumber on the project, you're hired by a GC. If that GC shares common identity with the owner, so maybe they share an office, they share the same officers and directors on the Secretary of State website. If that is the case, that common identity collapses the GC and owner category, and therefore you don't need to send a notice to owner. Again, I strongly recommend that you just have a process in your office that any job over a certain amount of money gets noticed. You don't ask questions, you just send notices when you have a job that's bigger than $500 or $2,500 or $10,000. Whatever you decide, those jobs get noticed. But what we find sometimes is clients will come to us and they say, oh, I forgot my notice to owner. And we dig around and we realize that the GC and the owner, the builder and the owner share a common identity. And if that's the case, then the notice to owner was not required. So no notice to owner, the next rule or the next exception, the no notice to owner, technically when it's a bond claim, which is what we're talking about, technically the notice to contractor is needed when you have a direct contract with the bonded contractor. Okay, so let's take another example. You're the plumber, you're hired by the general contractor. That general contractor on this project, whether it's a public job like a school or courthouse, or a private job, maybe multifamily, if that contractor has a payment bond on the project such that your claim is not a lien on the property but a claim against that contractor's bond, you do not need to send that first notice, the notice to owner, notice to contractor. If you're a sub, so if I'm a supplier to the plumber, I do need to send that notice to owner even if the contractor is bonded. But if I have a direct contract with the bonded contractor, I do not need to send that first notice on the job, the one in 45 days. So the next thing to look at is, did you really miss the deadline? So let's talk about a situation where people think that there was a deadline when there wasn't. So the most common is that no notice of non-payment, that's the claim on the bond, is needed when you have a direct contract with the bonded contractor on a public project. So let me give you an example. If I'm the plumber on a Miami-Dade County School Board project, so it's a public job, my contract is with the bonded contractor. According to the last slide that I just told you, I don't need to send that first notice within 45 days, that 45-day notice to owner, not required because I am a subcontractor to a bonded contractor. But if the project is public, then I also don't need to serve the notice of non-payment. That's the notice within 90 days of my last work. So if I am a subcontractor to a bonded contractor on a public project, I don't need the first notice and I don't need the second notice. The only thing I need to do in that scenario is file a lawsuit no later than 1 year from my last work against the bonded contractor and their surety. So did you miss the deadline? Well, you may, you have in your head that I always have to serve this notice of non-payment within 90 days of last work. That's not the case when you're doing work for a bonded contractor on a public job. Also keep in mind, another exception here is on bonded projects, the 45-day notice to owner, right? That's the first notice that needs to go out, doesn't even begin to start to run until you have actual or constructive knowledge of the bond. Let me give you an example of what that means. I'll give you an example from a client of ours with a story that came to us, a situation that came to us. So our client was the subcontractor on a public job in Florida. So As a sub, he needed to serve the notice to owner within 45 days and a notice to contractor within 90 days of last work. They had a mix up in their office. They did not do that. When he came to me, he was owed into the six figures. He says, Alex, I really screwed up. We had this change in the office. I never served any notices, and I'm owed this money. What can you do for me? So we did some digging, and we came to learn that the bonded contractor on that project failed to properly record a copy of the bond in the public records, which is a requirement. So we were able to uncover who the contractor was and who their bonding company was. Now, keep in mind, my client at this point had been off the job for 6 months, had been done, finished with his work for 6 months. So what did we do? We found who the surety was, and we sent them the notice to owner. Now, meanwhile, this is a year plus after the work started and 6 months after the work had finished. The next day, we served the notice of non-payment. That's the 90-day notice. And then the day after that, we filed the lawsuit. So again, all the deadlines, as I've just explained them to you, the client blew them all. But because the bonded contractor failed to timely record a copy of the bond in the public record, putting the world on notice that this job is bonded and here's who you make your claim against, none of those deadlines started to run. So we ultimately settled the case about 3 months in, and the client got paid all of their principal, interest, and legal fees. So this is an example of where the timeline didn't even begin to run because the contractor in this example made that mistake. So keep in mind, again, this is a good example that there are lots and lots of exceptions to the lien law. So even if you think maybe that you don't have any rights, you should still talk to a board certified construction lawyer to make sure that every stone is unturned, because maybe you have rights that you didn't even know about. Another thing to consider is maybe there's another bond to go after. So on jobs that either the GC is bonded or not, the subcontractor may be obligated to provide a payment bond. So as a subcontractor or a material supplier to a subcontractor, you may have rights against this subcontractor bond. So again, let me give you the example. There's an owner, there's a GC who may or may not have a bond, it doesn't matter. And then let's say there's a plumber. That plumber may have been obligated contractually to give a bond on this job. Now, the problem is you don't know about it. Because the only bond that needs to be recorded in the public record is the general contractor's bond, this sub bond will not be available to you in the public record. So how do you get it? One, you're going to ask the contractor for a copy. You can also ask the subcontractor for a copy, right? So you can send them a letter and say, please send me a copy of the bond if the subcontractor has a bond. Many subcontractors don't want to give you a copy of their own bond, right? Because they don't want you to make a claim against it. But if you ask the general contractor, they will almost always give you a copy of their subcontractor's bond, because they know if you have a claim, you're going to go after that bond and you're probably going to leave them alone. So they are more than happy to give you a copy of a subcontractor bond. Now, we see more and more subcontractor bonds being required, even if the GC doesn't have its own bond. So this is on larger jobs. This is a very good place to look, because you may have a claim against that subcontractor's payment bond. How do you make a claim? So let's assume that I am a subcontractor to the plumber on this job. What do? I'm going to send a copy. I'm going to send a letter to the contractor, say, hey, please send me a copy of the plumber's payment bond. I'll also send a letter to the subcontractor asking for a copy of their bond. When I get a copy of that bond, so someone's going to mail me a copy or email me a copy, how do I make a claim on that bond? What you have to do is you have to physically get a copy of that bond, and then you have to read it, the payment bond, and do whatever it says you have to do to make a claim. That's it. Some say you have to submit this list of documents. Others say you don't have to do anything. The bond is a contract, and to make a claim on that bond, you have to do what the contract says. And the only way you can do what it says is if you get a copy of it, read it, and then do what it says. That's how you make a claim on the subcontractor's bond. Do know that once you submit whatever you may have to submit, if you are not promptly paid, I would strongly encourage you at that point to seek out competent construction legal counsel, because you may have to file a lawsuit, because the 1-year deadline still applies. You need to file that lawsuit promptly from your last day of work on the job, even if the claim you're making is against the subcontractor's bond. Now, we have a handy tool that we mail out. It sits on your desk. It's called the Lien-O-Matic. It has all of these rules and many more in a handy desk tool. So if you're ever curious, is it 45 days? Is it 90 days? Are there any exceptions? Go to lienomatic.com, fill in your information. We'll put one in the mail to you. It's completely free. You'll get it in about a week, and you will be able to answer any of the questions you have about public jobs, private jobs, DOT jobs. The rules are different there. Federal jobs, which is the Miller Act, similar but still slightly different rules. All of them are in this device. All right, so let's talk about other claims. Let's say you've looked everywhere, we can't find a bond, we blew our deadlines. Who else can I sue? How else can I get paid? So the most common claim that you can make is to sue someone for breach of contract. So that is, you're going to sue someone that you have an agreement with. That agreement is with either a person or an entity. Ideally, the agreement is in writing, signed by the parties, but it is not required, meaning if you come to my house and you say, I'll paint your house for $10,000, and we write nothing down, and you paint my house, and then I don't pay you, we have a contract. You can still sue for that breach of the oral agreement, right? That's the breach of contract. So don't think that just because you don't have anything in writing doesn't mean that you can't file a lawsuit. Evidence of your contract could be a proposal, a quote, an estimate, your invoices. Obviously, if you can get the other side to sign it, it becomes much more binding. Ideally, you have some terms and conditions in whatever was executed. But again, none of that is absolutely required. It's just better. If you have a contract with a GC and you've signed their contract, you have to be aware that they probably have a pay when paid provision in the contract, meaning they don't have to pay you unless they've been paid. This is valid and enforceable in the state of Florida. There are some exceptions, but they're very narrow. So just know that if you blow your lien rights and therefore you cannot lien the property, and you signed a contract with a GC and that contract says that they only have to pay you if they've been paid, it's going to be much harder to get paid, because you don't have a proper legal basis to sue for breach of contract. If you have any doubts on whether or not the pay when paid provision is valid, because there are exceptions, you should talk to a construction lawyer who can read that provision and tell you whether it's valid or invalid. So let's talk about some other claims. Unjust enrichment is another legal claim you can bring. The theory is simple. You have not been paid. That's the unjust part. And you've conferred a benefit. That's the enrichment part. You have enriched someone, and it is unjust for them to keep the value of what you've provided without paying you. So typically, this is a claim that is brought against someone further up the chain. You can bring this claim for unjust enrichment against the party that hired you if they've been paid. But typically, we use it as a claim, as a secondary claim against an owner with or without a lien. So if you're the plumber on the project and you haven't been paid, you can sue the owner, you can sue the contractor potentially for breach of contract, but you could also sue the owner for unjust enrichment. Again, this is assuming this may apply even if you have a lien or if you don't have a lien. You would sue the owner for unjust enrichment. The argument is, I improved the owner's property and I haven't been paid. The major defense that you run into is that if the owner actually paid the contractor, even if the money didn't get to you, the unjust enrichment claim will not be valid, right? Because we don't have both parts. We don't have the unjust part, right? We have the enrichment part, the owner's been enriched, but we don't have the unjust because from the owner's perspective, they have already paid someone for the value of your work. It just didn't make its way to you. So if the owner has paid the contractor for your work, then there really is no legal claim for unjust enrichment. Typically, you don't know all of that until you get to a legal case, but those are things to keep in mind. So let's recap. We went over the basic rules. We talked about making sure that you exhaust all available exceptions to the lien law. We talked about some of them. There are others. So just don't give up when you believe that, well, I missed the lien deadline. I guess I'm out of luck. Remember, you can get our free Lien-O-Matic desk tool at lienomatic.com. And you can have this on your desk so that you can know and have available to you all of the rules. You want to check to see if the subcontractor is bonded, because maybe they are bonded, and if so, you'll be able to make a claim against that subcontractor's bond. And then you can always sue for breach of contract and unjust enrichment. And with that, Jesse, we are done. Do we have any questions?
First of all, thank you, Alex. As always, you really are incredible, so I appreciate it. We do have a couple of questions that have come through so far. The first one, it says, the property is being sold to a new owner and I haven't been paid. I'm scared that the new owner will benefit from all my work and the owner will walk away. What can I do?
So my first question would be, do you have a lien? Ideally, you have a lien, because if you have a lien on the property, then it's not that it's impossible for the sale to happen, but it complicates the sale significantly if you have a lien. So if you still have lien rights, you should exert those lien rights. If you don't have lien rights anymore, or if the lien period has expired, then your remedy is going to be to sue the contractor for breach of contract, whoever hired you, or by the way, if the owner hired you, you would sue the owner. But you won't necessarily be able to prevent the sale without a lien. But again, it doesn't mean that you have no legal rights to pursue the claim.
Okay, all right, perfect. Thank you so much. Another question that has come through, it says, on a private job, if the bond is not recorded, nor is it mentioned in an NOC, and we never got the bond, if we get a copy of the bond late, does the timeline start to begin once we get the bond on a private commercial job also?
Yes, the answer is yes. Yeah. So
okay.
if that were me, well, ideally on a private job that you did not think was bonded, you would have followed all the rules in order to perfect your lien rights, right? So you would have timely served the notice to owner, assuming that you're still working, you wouldn't need a claim of lien, but if you were done, then you would have recorded your claim of lien. And then at some point you've come to learn that the job had a bond, then I would send a new notice to owner, now listing the bonding company. And if you're owed money on the job, I would then immediately serve a notice of non-payment. And yes, generally, if they did not record a copy of the bond, did not attach it to the notice of commencement, did not reference it in the notice of commencement, such that you had no way to know about it, those deadlines have all been extended.
Okay, wonderful. Thank you. Another question, it says, what happens if you file an NTO at the beginning of a job and it expires? What can you do if you didn't realize that it had expired?
Okay, so let's make sure we're talking about the right thing. A notice to owner never expires. So maybe we're talking about a notice of commencement. So let's dovetail the question in that way. So when a notice of commencement is recorded, so the notice of commencement is typically prepared by, but definitely signed by the owner, and it lists who the owner is, who the contractor is, and it has an expiration date. That expiration date, if left blank in the standard form, is 1 year, but you can put in any date you want, 6 months, June 7th, 3 years. If the notice of commencement expires and you are still working on the job, you still have lien rights. The only issue is that if you record your lien after the notice of commencement expires, then your lien is effective as of the day you record it, versus if you record the lien while the notice of commencement is still active and pending, it relates back in time to the moment, the date and minute, hour and minute that notice of commencement was recorded. So it kind of acts like a little time machine and brings your lien all the way back in time to when that notice of commencement was recorded. But as far as the underlying question, you know that your notice to owner never expires unless the notice of commencement is terminated, and you should get notice of that, or if you issue a final release. And then if you go back on the job after giving someone a final release, you need to send another notice to owner.
Okay, wonderful. Thank you so much. Another question that has come through, it says, if a GC files bankruptcy in the middle of a project and a new GC takes over, what happens to my current contract and current NTO?
So it depends. If it's handled correctly, the notice of commencement should be terminated, because now the owner needs to fill in a new notice of commencement listing the new contractor. And if so, to terminate the old one and record a new one means that you will need to send a new notice to owner once you are notified of a new notice of commencement. That may or may not have happened in your situation. Also, if you are doing work for a contractor and that contractor went into bankruptcy and a new contractor is on the job, your contract, unless you receive what's called an assignment, which usually an owner can do, but you would get this paperwork, assign your subcontract to the new contractor. You need to, if that hasn't happened, then you need to take some action in order to cause that to happen, or you need to sign a new contract with the new contractor. And yes, you should send a new notice to owner, ideally within 45 days from when you started work for the new contractor. So you would think of it kind of like a new job, but again, with respect to the contract, you need to get either an assignment or a new contract.
Okay, wonderful. And then another question that has come through, if a homeowner gives you a check and stops payment on that check, what are the rights against the homeowner?
So we've done this presentation before, and I know we're going to be doing it again in 2026. So the first thing I would tell you is take a look at the SunRay YouTube channel or the SunRay website, and you'll find a webinar where we talk about this in great detail. The short version is, if someone puts a stop payment on a check, there's a special letter you can send that requires that they make good on the check within 30 days. If they don't make good on the check in 30 days, then they are potentially liable to you for the amount of the check plus an additional 3 times of the amount of the check. That's called treble damages, plus your legal fees and costs. It's also potentially a crime to put a stop payment on a check, so you may be able to report them to the state attorney's office.
Okay, wonderful. I do think that that's all the questions that have come through. If you do have another question that wasn't addressed, please feel free to reach out and I'll try to be sure to answer any questions for you. Can you go to the next slide? Perfect. Please check out our new services that SunRay is offering. SunRay will handle your commercial collections for you. We're here to help you guys get paid. So if you have any specific needs, give us a call and we can definitely talk to you about what we can do for you. All right, the next slide, please. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. And then the next slide, if you don't mind. If you have a moment, this only takes you about a minute. We really do appreciate any feedback you're able to provide to us. So go ahead and scan this QR code to provide that Google review. It really does help us out and make sure that we're getting the content out for you guys that you guys are looking to learn about. All right, and then the next slide. And with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you guys at our next webinar in 2026. I hope you all have a beautiful and wonderful holiday season. Again, Alex, I can't say thank you enough. You really are incredible. Happy holidays to everyone. Have a wonderful day. Thank you guys, everyone.